Morning, one and all. I welcome all of you all to the first session of the finale of the India ADR Week 2021. And boy, what a captivating week it has all been. Today, I, Gaurav Sharma, am your master of ceremony, and I will be bringing to you this session, which is titled Bridging Distance for Dispute Resolution. Now, this session is sponsored by CADRE, SAMA, and COD. In this particular session, as one would know, this is an absolutely unprecedented times that we are living in. And we have all been challenged on various fronts. Particularly, courts of justice cannot be closed, nor could the dispute resolution mechanisms, which is why, with great pride, I have to introduce all of y'all to the online resolution revolutionaries, who are Kanchan Gupta. She is the co-founder of CADRE. Pranjal Sinha, he is the co-founder of SAMA, and Mr. Vikas Mahendra, who's the co-founder of COD. Lastly, and more importantly, I have to introduce Mr. Pramod Rao, who's the Group General Counsel, ICICI. Now, Mr. Pramod Rao will be the moderator of this particular session, and I would encourage all of you all to, question us as and when you all possibly need and find the need, so that we can then answer and address all your queries, particularly in the last 15 minutes. So this session would go on from 10 to 11. Even in the meanwhile, if there are any queries that you may have, please feel free to text us in the Q&A section, and our panelists will endeavor to respond to you quickly. I now hand it over to Mr. Rao.
Thank you so much, Gaurav. And indeed, my thanks to both Neeti, Madhukeshwar, the MCIA team that has got us all together in this finale to the India ADR week. We hope to do justice to the topic, which is really bridging distances for dispute resolution. And we have three pioneers from the ODR space here, Vikas, Pranjal, and Kanchan. Before we, sort of dive into the conversation, I thought I'll just do a minute of context setting. I think ODR, for all its, various forms, permutations, and so on, has been around for at least 20 plus years. It's just that probably in the last 1 year, we have discovered far more of it, hastened because of the COVID situation, but also because I think all of us are in some senses searching for means to actually have dispute resolution resolved faster, resolved in an equitable manner, in a fair manner. And I think a lot of what you will hear from the pioneers today is going to be, how they have both conceived of it, thought of it, and what they have brought together. And I know there will be, issues in any form of dispute resolution platforms that are used, institutions that are used. So I'm also hoping the conversation today informs us about, how these pioneers see those issues. And hopefully we will be able to resolve also your queries, clarifications, doubts, because it is a nascent area in the country. And I'm quite looking forward to these conversations. So very quickly, if I can just move around the table in terms of, maybe beginning with Kanchan, you first, in terms of that, what is it that you see ODR as? And certainly that it is seen as something little more than just providing video conferencing facilities. But over to you, Kanchan.
Yeah. Thank you so much, Pramod. A very good morning to everyone. First of all, a big shout out to MCIA for organizing the India ADR week. And, even more so, thank you so much for having us, new kids on the block, participate amongst so many other august participants that you've already had. So thank you so much. Coming to ODR, the definition lies in the term itself, dispute resolution, right? Now, getting into a dispute is worrisome enough. The process of resolution should not be painful. And that's where I think the genesis of doing something simpler, easier, hassle-free kind of came about, and we started CADRE. So ODR, I believe, is about bringing dispute resolution to your doorstep, right? So it is online. Law is just a framework, and technology is the vehicle that carries it forward. So we should see ODR as more of solving a social and economical problem versus a legal or a tech problem. And that's really the basis of, what we think of online dispute resolution as.
Thanks, Kanchan. Pranjal, your thoughts on ODR and what it connotes?
Thank you so much, Pramod, and thank you again, MCI, for hosting us today. I think, first of all, like ODR owes like a debt of gratitude to ADR, Alternative Dispute Resolution. It's because, in principle, ADR made it acceptable to resolve disputes out of court. But ODR at the same level is like an evolutionary leap from what ADR is. And in very obvious ways, because first is it's fully technology driven. So your end-to-end resolution is online. It's also fully data driven. So there's a lot of data which you get when you're running cases on an ODR platform. So you can look at patterns and you can actually solve for disputes and actually prevent those disputes from happening in the future again. And then also at the same time, you get access to like high quality mediators, arbitrators, conciliators across the country. So that pan-India access to one litigant in one city is something which is exceptional. It's an exceptional component of ODR. And talking about video conferencing, I think the 80% of ODR which Sama does is actually not video conferencing. It's actually a lot of asynchronous conversations where conciliator speaks to the parties and they're able to get proposals, and then the other party sits in the evening and responds to all proposals. So ODR is beautiful. It's, as you say, it's like an evolutionary leap from what ADR was, and it's definitely the future of dispute resolution in India.
Thanks, Pranjal. Vikas, your thoughts?
Echo everything that's been said, both in terms of a thank you to the MCIA and in terms of what ODR is, and just in terms of what the process itself entails. Like Pranjal was saying, it's like Lego blocks the way we see it, right? ODR is not one framework where everything has to happen. It is what you want to pick and choose and make part of online dispute resolution. The minute you're using technology, the minute you're using an online medium to communicate with the parties, the minute you're using it for storing documents, case documents, etc., you're making it ODR. And the greater the use of technology, the more full-fledged the ODR offering is going to be. But even if you're using technology to the simple extent of using emails for the purposes of serving copies, that's ODR. And I don't think we should take away from it. But I think what we're seeing as a shift is an embracement of a slightly more holistic concept of ODR, where right from the time a dispute arises, sometimes even before a dispute arises in a sort of call center level, from that time till the time you get either a settlement where parties have agreed and walked away from the equation, or there is a binding resolution, you're seeing everything end to end being resolved on an online medium. That's where ODR has transformed itself in the last year and a bit. In fact, we're seeing a lot of pioneers who are even experimenting with automatic dispute resolution, where there are not even physical neutrals who are present there. So there's a whole host of options that are available. So to straitjacket or bucket them into a definition, in my view, would be counterproductive, because that would be stifling innovation. What we are doing is only one subset of what ODR can be.
Thanks, Vikas. And I suddenly became conscious that all of you are co-founders of one institution and the other. So maybe a quick roundabout from all of you for our audience as well, as to what is it that uniquely probably your institution is doing. I know there will be a lot of commonality, so probably just calling out a few aspects. And because maybe I'll start with you, and if you can describe it, and then we'll hand the baton over to the next.
Sure. So CORD is Center for Online Resolution of Disputes. We are a dispute resolution institution. So we do everything from mediation to arbitration to any modification of that process that parties want. And we are, like I said, we are Lego blocks in the true sense of the term, in that we offer our offering in a piecemeal fashion. So if people want us to simply appoint a neutral, we provide that service. If they want us as a simple virtual hearing room that they use for their arbitration proceedings, or for transcription, or for witness observers, anything, there are various stages in a dispute resolution cycle. We provide those services in a piecemeal fashion if parties so desire it. But if parties so desire, we have a platform which is designed to take a case through the entire life cycle of it and provide parties the solution that they need.
Thanks, Vikas. Kanchan?
Thanks, Pramod. I think CADRE was set up with a mission to democratize dispute resolution, and we are built on the principles of user first, usability first, and arbitration first. So therefore, we've kept the disputing parties, the arbitrators, in the middle of this entire process, in the way we thought about how we want to build this and the way our entire system is designed. And we focus on arbitrations primarily. We run always on arbitrations, and our USP lies in completely eliminating paper. And off chance, if at all, we may need to use paper, but we've been strong proponents of the fact that true justice does not need paper. We've been able to build a very good curated capacity of arbitrators by training existing lawyers, non-lawyers, retired professionals, women returning to work, by putting them into a training program, which helps them build a progressive mindset, a digital mindset to how to resolve disputes, giving them decision-making, skills on what to look at disputes and how to come to decisions. So those are the frameworks that we have been training people on, and we've had reasonable success with it. Recently, CADRE also launched a Sas platform, a software as a service platform, for arbitral institutions, for law firms, for any organization that wants to run their own dispute resolution platform, without having the end-to-end ecosystem service that we otherwise provide. And I think the USP lies in the fact that this is coming from a place of experience, right? So we have built the system, we have run 300 plus claims on this successfully in the last 2 years. And we've taken out all the kinks from it and built a system that is tried and tested. And yeah, that's what CADRE does. And I think that's what's required now in the real world as well.
Very, very important takeaways, at least I had. Documents only, the training that you are doing of including people. And I'll come back to some of these themes a little later, Kanchan, but over to you, Pranjal, if you want to, sort of describe Sama.
Yeah, thank you, Pramod. So we started the journey 5 years ago with the intention to help people resolve their disputes collaboratively and efficiently. Sama is a neutral and independent ODR institution recognized by Ministry of Law and Justice. We have more than 2,000 mediators, arbitrators, 1,500 case managers. In the last 1 year or so, we have handled more than 160,000 disputes with a settlement rate of 25 to 30%. It's again operates at two levels. We have the institution, our own rules and procedures to provide online mediation, online conciliation, online arbitration services. But simultaneously, we also offer our platform to legal service authorities and other neutral dispute resolution agencies. The motto has been "Sulzhaओ मगर प्यार से," and that's what we are committed.
Thanks, Pranjal. Quite a lot of statistics that I heard there. And again, we will come back and probably hear some of it. What I wanted to do, and especially, both my own position as an in-house counsel, but also several of you are, I know Vikas is part of a law firm as well. If we could hear some of the success stories, some of the things which will warm the hearts of both the community, but also probably those sitting in law firms or in in-house teams to sort of say, yes, this will make me embrace ODR. If you'd have examples to call out, maybe Pranjal, if this one I can ask you to start with, and then we'll go around the room.
Sure. Okay. So let me divide into two parts. First, with respect to enterprises, I think so. Like recently, we saw e-commerce cases which were filed by consumers against the entity. In consumer forums, which has been pending for 2 to 3 years about electronic items. The case got resolved through online conciliation in a matter of less than 10 days. And then the conciliation was enforced in that consumer forum, and the case was withdrawn by the complainant against the enterprise. So I think from an enterprise perspective, they were doing it because they said that we care about the customer, and that consumer has been against us for the last 2 years. The consumer was fed up to continuing that litigation for 2 years. So when he got a notice from Sama saying that, hey, there's an opportunity to settle that case, and these are the kind of waivers, offers you can get, and they were able to reach a settlement. So I think in a very true sense, like this was, today e-commerce companies run on being customer-centric. So dispute resolution also need to be customer-centric. So it makes sense for your in-house legal teams to adopt such a customer-centric dispute resolution mechanism. Similarly for, like, I think one of the B2B marketplaces who we are working with, even when the pandemic hit, a lot of people were facing troubles due to cash flow crunches in repaying the loan amounts, or maybe whatever credit they have taken from the logistics arm, etc. But again, due to online conciliation processes, with the help of a neutral conciliator, they were able to reach a common ground which worked for their cash flow situation, and at the same time it was acceptable and within the policies of the enterprise. And the customer got retained. And he, like, when we were taking feedback from that customer, he said it's like somehow as a godsend, like we weren't expecting such a thing to happen. So when you hear those things, like it gets validated that it's about thoughtful technology, it's about empowering the litigants, both the enterprises and the customers. And I think the third is online lok adalats for us also, because online lok adalats for us was not just that online dispute resolution works in tier 1 cities of Delhi, Jaipur, or Delhi, Jaipur, or Patna, but it also works in tribal areas of Churu, Munger, where people were from these tribal areas. They were able to come on the platform and they were able to settle their electricity disputes. They were able to settle their insurance claims. They were able to settle their loan disputes, accident insurance claims, all through an online platform. So making technology comfortable with people instead of making the person comfortable with technology, I think that was the intent. And these are few success stories which really validates and shows that ODR can work in India. So yeah.
Thanks, Pranjal. Vikas, from your both viewpoint, both as I know you're a qualified arbitrator as well, but more in terms of the institution, COD, if you can.
Yeah, so I'll share a couple of stories. The first one I think is similar to what Pranjal was saying, which is, sometimes when clients come to us, one of the difficulties they're expressed is their inability to reach out to their customers, because a lot of times, they've probably had, emails sent, they've probably had couriers and postal sent which have not been responded to. So they've simply lost touch with their customers, who may eventually come back to them, get their accounts regularized, and go ahead and do things. What we've been able to achieve, and that's something that the companies have been really grateful to us for, is actually make that connection. Because we use, for instance, email, WhatsApp, telephone conversations, everything. Like there's about 6 modes of communication that we use to reach out to the litigant. So that bridge that we help build as part of the services that we offer has been incredibly helpful to people, because just that communication channel has automatically resulted in a lot more settlements than they would have been able to achieve otherwise. So that communication channel is one. That's as an institution. But as an arbitration service provider, we've had a lot of success with a variety of parties. So for instance, we've had mediations conducted where parties were all across the globe, like literally dotted all across the globe, people participating in a video conference platform with a breakout room that they can use, with a main hearing room that you can use, all of those things that they were able to access. Maybe because of the pandemic, it became the norm, and they were actually able to do it with such little cost to the parties that they were incredibly happy about it. Equally, we've had situations where we've used our platform for resolving disputes which has nothing to do with India. So we've had one dispute, for instance, where there is 2 Mauritian parties, Mauritius arbitrator who is resolving that dispute, showing clearly that boundaries don't matter. And the technology that you offer, if you are sticking to your core principles of data privacy, security, consistency of the quality of information, that is that people will embrace you and people are willing to adopt you. So that breaking down of barriers was a huge success story for us, which actually made us feel quite happy about things. And in this context, I'll probably take one of the questions that's been asked also by Ashwin, a dear friend of mine also, as to why is it that we can't integrate with existing platforms? And that's in fact something that we actually do and very consciously do. So for instance, if someone says, I'm more comfortable with Zoom, and rather than force our video conferencing engine on them, rather than force whatever solution we have on them, we say, use Zoom. But do you want transcription service providers? We will provide you transcription. We'll plug and play, because we've identified certain existing popular frameworks which can, take our services on board for them. We plug and play the transcription, witness observer services. We provide that sort of support network which would otherwise be available. So we work with the people to try and figure out what they're comfortable with. And sometimes if they don't want to use a video conferencing, they just want to pick up the phone and speak to people, we do that. So we've had our institution have conversations over phone where people simply don't want to have access to a video conferencing engine. And that's been fine as well. So it's about working with each individual, each case in each situation, and trying to adapt ourselves to what is the needs of that community.
Wonderfully said, Vikas. And Kanchan, over to you. Your own experiences, as you said, spanning 300 cases in the last 2 years. And I was particularly smiling because it happened during COVID, really when people had to, sort of think of alternative as such. But
yeah. And I think you've given me a nice segue there, Pramod, when you said that this happened during COVID. So, one very heartening instance that I can share, in continuation to what you said is that, way back in 2019, when we were reaching out to organizations to adopt ODR platforms or an online arbitration platform, there was a ton of skepticism and apprehension that, will this even fly? Will this be recognized? We don't know. And, there was very little uptake, really. And come COVID and come April 2020, the same people were coming back saying that, okay, you know what, let's give this a shot. Looks like there is finally some credit to it. So I think that was very heartening to see all those people who was sitting on the fence to kind of take the plunge and come to the other side of the fence. The couple of incidents that I'd like to relate that that kind of makes you feel humble and very thankful for what we are doing. So during our arbitrator training and empanelment process, we've been because it is virtual and because it is online, because everything can be done from the comfort of your homes or whatever other place you find comfortable. We've been able to reach out to arbitrators uh, across the country, across all strata, right? So tier 2, tier 3 cities. So I particularly remember this one thing, that a lady, she's a lawyer based in a tier 2 city in Gujarat. And she had come to us for being trained and empaneled. And when she went through the process and she actually handled the cases, she was in awe, saying that, at 50 plus, you have taught me a new way of working. And I'm so grateful that I don't know if I would have ever seen something like this in my lifetime. I'm very happy to see that, all this progress is being made. Being in tier 2 or tier 3 cities, we don't even, apart from going to court and filing a few papers and coming back, we don't get to see the rest, any other part of the world. So that was very, very heartening. And the other thing is, we've been fortunate enough to work across different segments, right? So starting from e-commerce to housing to logistics to there was some call center disputes. We've had consumer disputes. Banking and NBFC is really the most common. So given that we've been able to traverse across all those segments, there is this one, not one, there have been a few, but there's this one which was very heartening, where we had the respondent based out of the US, right? And I think that's where we saw how efficient our platform became. That it was all what we like to refer to as always on arbitration. You can put in your response anytime. You can file your documents at any time. You do not need to wait for a time and place to do it, right? And that, I think, is so powerful when it comes to online dispute resolution. And in so given that we started off, our initial claimants were mostly organizations, right? Companies, whether it is e-commerce companies or B2B companies, logistics companies, NBFC, so on and so forth. To see actually in a very, even though it's a small number, a case going in favor of the respondent. And for us to get the feedback that, initially when I started getting this communication from CADRE and from XYZ company, I thought you were, working together against me. But we've got the confidence that this is a neutral organization and it is not working in favor of anyone, but working, the term they used was working towards, resolving disputes. And I think these are things that make it worth every challenge, every trial that we go through during this process. And most importantly, this pandemic has, given a lot of people, while it has given an uptake to a lot of people, it has also given a, downslide to some. People have lost jobs, they've lost pays. And we are proud and yet very humbly say that in about 6 months of time, we were able to see money exchange hands between parties. We were able to disburse more than 400,000 INR to in arbitrator fees in a period of 6 months. And I think that kind of humbles us and makes us feel proud at the same time. So yeah, all of this makes it just worth everything else that we go through.
No, quite so, Kanchan. And I think you all have reasons to be proud of having, and that's why the topic also sort of resonates with me, bridging distances. You're saying, Vikas said around the globe, you're saying across in the US, and, Pranjal talking about even the hinterlands of Rajasthan. So to me, I think indeed the potential of this platform and the technology is really marvelous. To me, just for the benefit of the audience, again, NITI Aayog has become a big proponent and supporter of ODR. We had Justice Sikri, who chaired a committee, and the title itself of the report, "Future of Dispute Resolution," is ODR. I think is one of the biggest endorsements that I've seen come from the policymakers. Very quickly, and probably again. With how the law also keeps changing, right? I wanted Vikas to begin with you in terms of both talking about the moving finger of Supreme Court pronouncements, decisions. Have they been good, bad? How have they impacted the ODR institutions? And similarly, if there is any changes in law that have been either supportive, detractive. So over to you on
that. Thanks, Pramod. There's actually been a mixed bag there in terms of laws and how the courts have interpreted it. I'll talk the positive first and maybe next the negatives. The first one is on the support for institutional arbitration, which has come from the legislature without mixed signals there. There has been a clear law commission report followed by an amendment to a legislation, followed by an MCIA is a big beneficiary of that also, and a proud beneficiary, where the Supreme Court's appointed the MCIA as the appointing authority in a number of arbitrations. So that is great testament to the fact that as a country, we're moving towards recognizing institutions which can help people resolve disputes, and therefore assisting the court system in solving some of that backlog. So that's been the biggest positive so far as I can see from the legislative side. On the sort of flip side are a couple of judgments which I'd like to point out. One of them is Vidya Drolia, where unfortunately they suddenly say that any dispute that can go to a DRT is no longer capable of being arbitrated, which goes against the grain of a number of earlier judgments where parties had the option to choose. So a bank, for instance, could choose whether to go to the DRT or to go to arbitration. But now with one clean swipe, Vidya Drolia has made it impermissible for banks to do that. So that's taken us a few steps back, because if you look at actually the arbitration landscape in India, what people see in your courts, what people see in your journal articles is 0.01% of the number of arbitrations that happen in India. The 99.99% of the arbitrations are actually done behind the background by mostly your banks, your non-banking financial institutions, your lending institutions, and even a number of government agencies. And all of those are no longer, firstly, they're not recognized. And the Supreme Court with one clean swipe has done away with a number of them as being non-arbitrable. So I think that's one thing that's certainly pinching a lot of the institutions, which should hopefully go back. The other one is on this appointment, unilateral appointment of arbitrators, which is probably a mixed blessing. I don't know if it's positive or negative, but hopefully there'll be some clarity on it, which is the Perkins-Eastman judgment, where we know a number of contracts in India, government contracts, private contracts included. And in fact, if you look at a lot of your, like Vakil Search, right? If you look at their standard form contracts, they have unilateral appointment clauses because that was the norm. So if you look at India, about 90% of the contracts had unilateral appointments of arbitrators. Now, suddenly all of them have vanished because of Perkins-Eastman, which say that, it's no longer a valid practice. Now, that might be a blessing in disguise, because what it might be is, it might empower institutions to make that appointment on behalf of parties. But some clarification there would be helpful. But as things stand, that's again one of those judgments which has been a little bit in the stumbling block for the ODR institutions, because a number of contracts, at least we see, are contracts where there is a unilateral appointment of arbitrator clause. So there is still some uncertainty as to whether it is enforceable, what's going to happen in the future, etc. So it's a little bit of a question mark. But maybe I'll sandwich this with some good news is, so far as online hearings are concerned, there's definitely been a positive uptake. There's in fact an Andhra Pradesh High Court judgment where an International Chamber of Commerce award, which was done entirely online, was enforced and security granted. So recognizing that courts also don't see physical hearings as being necessary anymore. So that way, it's been a bit of a mixed bag, but hopefully over time, we'll all turn towards the positive.
Thanks, Vikas. Pranjal, Kanchan, anything to add to Vikas's, outline of both the mixed bag that law and Supreme Court decisions have been?
I just have something very small to add. I'm not a lawyer, but in the overall scheme of things, I think whatever is coming has been very helpful. If not today, maybe tomorrow things will, kind of get better, and there'll be more in terms of such judgments which aid in making dispute resolution accessible to everyone. As an entrepreneur and a business owner, we just need to keep, working with what we have, and and then just keep moving on, making that dent.
No, quite right said, Kanchan. And to me, the point Vikas made about Perkins Eastman, I guess before Perkins Eastman, we all looked at it as that once the person is appointed as an arbitrator, he has to function neutrally. It really doesn't make a difference in terms of who appointed and so on. But it's the law which changed thanks to the Supreme Court pronouncement in saying that since the person appointing is also a party to the dispute is why it should be taken out. So I guess some of these we will continue to see as to how both the law continues to evolve. Pranjal, you have something to add? Yeah, please go ahead.
Right. Yeah, I think like two aspects. I think recently there was a Supreme Court judgment by Justice Saran, I believe, where they said that if you're settling matters through private mediation, you can still recover the court fees. And I think that helped us in making a case to enterprises that not just your pre-litigation cases, but even your post-litigation cases, you can try to settle it outside court. And that judgment sort of gave a push for that. And I think secondly, I think big credit to the work being done by Niti Aayog and Agami and pushing for the ODR ecosystem in India. Like, their hats off to them. I think they played a major role in creating that level of awareness, and we are having that handbook launch. Supremely exciting, yeah.
Quite so, Pranjal, quite so.
Sorry, Pramod, I can see there's just one more point that I wanted to mention, which I missed out, was the Ministry of Law and Justice's initiative to recognize ODR institutions. Now, we've seen a lot of reports, but what has also come in is there's been some concrete action taken on the basis of those reports. So where the Ministry of Law and Justice invited all of us to say, what are you guys doing? And that's recognition from the government level, which is very encouraging, because obviously once there is a list put out, hopefully soon, and that list recognizes ODR players as a distinct actor, recognizes as valid actors in this ecosystem, that will give a huge boost to it. So I think that's also something that's worth specifically highlighting when we talk about laws.
We should. And I quite, both, while I called out Niti Aayog, I think indeed the embrace from the ministries, as you said, has been great. The Supreme Court justices, several of the High Court justices, I think they have equally been big supporters and proponents of ODR. And to me, that is where, at some level, the naysayers, I've ended up hearing sound bites from both law firms who end up telling their clients, hold on or hold off. That's one part. The other is to saying, and indeed, where some folks have told me, well, we use Zoom or we use WebEx, and isn't that ODR? To do connect their arbitrators or their neutrals on the platform. How would you respond to that? Maybe Vikas, first with you, and then around the table.
Now, I'd say that is ODR, but is that enough of what you can make of the system is the question, right? So if you want to just, for the purpose of a checkbox, if you want to say I'm using Zoom, therefore I'm doing ODR, fine. I mean, I don't know what that achieves. But are you realizing the full potential? And I'd say the answer is no. Because if you look at it, even the courts are doing significantly better than that. Look at the e-filing system that the Supreme Court themselves have launched. If in a court system where across India, across the diversity, the district courts, the complexities of the matters, you're able to file things online, why can't you do that in an ODR setup? If you're filing it online, why is it that you can't have a repository online? Why can't you have a properly searchable format? If you are able to do all of that, why can't you use it to serve people? If you are able to serve people, why can't you use that online record as an evidentiary trail for the purpose of any subsequent proceeding? So it's all small logical steps that will follow. And if you take it, then you'll come to the conclusion that maybe this video conferencing is a small part of it. It is a part. Maybe if you're doing it, it is ODR in some senses, but it's certainly not realizing its full potential.
Quite so. And again, I saw one of the questions, so let me try and tackle that. Why I keep bringing up law firms is that law firms end up advising a host of clients. And to me, as many clients that they recommend the ODR institution to, or the use or harnessing of it for dispute resolution, is that much more Philippe, I believe, to the ODR systems. And again, it is Justice D.Y. Chandrachud who actually said that we have to start thinking of justice as a service, that it can't be just seen as merely resolving disputes, but in fact, rendering justice is what ODR institutions also enable. And I think that's the real sort of beneficiary or the boon to the society as well. Pranjal, would you like to have anything to say to those who are fence sitters, thinking about why should they embrace ODR?
Right, right. So that's what I think a lot has changed in the last 1 year. Like, not to cheerlead on the pandemic, it has really pushed, and now there is enough data for you to see that these are the number of cases referred, these are the number of cases settled. Out of the cases settled, this is the compliance rate of the conciliation awards and arbitration awards. So don't go by what we are trying to sell you. Like, look at the data and you can make a much more informed call. And yes, video conferencing is there, but I think ODR is like a business intelligence decision. It's a smart business decision to make, because you can solve for disputes, you can ensure that fewer disputes happen in the future. So it's very important that law firms and lawyers look at it in that manner, like law firm, while they're advising clients, and also lawyers started looking at it more from a supplier perspective also, of how they can also become mediators, conciliators, arbitrators, and meet the demands of the enterprises or the people who want ODR services.
Thanks, Pranjal. And indeed, that's something Kanchan had touched upon. And I think some bit of interest that I can see in the questions as well. That is that given our number of people who graduate as lawyers, but equally those outside of the legal field too, who can train up to be neutrals, who can participate in this ODR systems. I think each of you has something going on in that space, right? So maybe Kanchan, if you want to again elaborate again for the benefit of audience and for us to amplify thereafter.
Right. So completely agree, Pramod. And I think when I, as a non-lawyer entered, started working on CADRE about 2.5 years back, I saw that mostly whatever existing arbitrators where there were either lawyers or judges. And, and when I started reading up on the act, I realized that there was no such, requirement. It is about having the right moral compass. It is about having sufficient worldly knowledge of how things work, and having the soft skills of people management and decision making skills, right? Judgment and decision. That's what you need. It's actually more common sense than anything else. And therefore, we set up 2 training programs. A digital arbitrator program for lawyers, and become an arbitrator program for non-lawyers, right? So both of these programs have seen a good amount of uptake. So we've had on our arbitrator panel, we have CAs, we have teachers, retired school principal, we have ex CXOs, right? CFOs and COOs who have kind of now called it quits with their full time, and this is something they're happy to kind of add to towards their second half. And banking professionals, retired banking professionals, these are people who have trained with us and continue to be part of our arbitrator panel. And I think that's the way to grow this, to grow the breadth and the depth on this capacity building. And there's enough and more to be tapped. There's enough and more out there in our country to be tapped when it comes to skills and capacity.
Thanks, Kanchan. Pranjal?
Right. I think agree. Again, echoing what Kanchan says, and like, so capacity for an ODR service provider is a challenge. Even I think when we are able to say that we have 1,500 mediators, arbitrators, or 1,500 case managers, I think there is still a challenge with respect to quality of them. And I think there's a tendency to keep going back to those 50, 60 mediators, arbitrators who we know they have proven themselves. So we also don't want to risk it, and the cases keep going to them. But the challenge for them, it becomes that they really have to recontextualize, because they're handling one use case for 7 days, and then immediately next week there's another use case, and there's another set of people, another enterprise, another set of customers to coordinate with. So we see that it becomes challenging for the same person to continuously work on multiple use cases in the same period of time. So I think that recontextualizing, and it's important for us to provide those trainings, or maybe have subject matter expert panels of different mediators, different arbitrators, so that whenever different use case comes in, we can accordingly appoint neutrals to deal with. But again, saying that, I think it's a brilliant career. So even for, like, I believe a lot of law students and young lawyers will be attending this program, there is a great opportunity to make a career in the field of dispute resolution. You can start as a case manager, you can start as a shadow mediator, shadow arbitrator, work yourself up, work your cases, do 10, 20 cases, get good feedback from the parties, then start doing co-mediations, co-conciliation, get good feedback from the co-mediator, then become a full-time mediator, conciliator on the platform. So there, and we have also seen like conciliators, mediators making above 1 lakh in a period of 1 month. So this is not a pro bono profession anymore. This is not an evening activity to do. This is not something to do on Saturdays, Sundays. You can really think of this as a full-time profession. So that's all I want to say.
Thanks, Pranjal. Vikas?
I think both of them have hit the nail on the head in terms of, one, what is the offering, and second, what are the skills necessary. But I think I just want to take a step back and tell people what really is the demand, right? And people may not appreciate it. One single entity, if you take a non-banking financial type of entity, one single entity churns out in the region of about 5,000 to 6,000 disputes a year. And you're talking about one entity. You extrapolate that, you're talking of hundreds of thousands of disputes which are there, which need dispute resolution professionals, which needs quality dispute resolution professionals who can do the job. So the kind of upskilling that we're talking about, it's not one seminar where we do it for 20 people and that's done because we have our arbitrators, we have our mediators. It's a constant journey. It's a constant process. Like Pranjal was saying, quality becomes an issue. You want to beat out poor quality. You want to ensure that you keep good people there, remunerate them well. These are all huge challenges that ODR institutions are facing. But that's also an opportunity for a number of younger professionals, especially, you're looking at the number of law schools across the country, the number of lawyers they're churning out, the kind of salaries that younger junior lawyers earn is abysmal. So it is truly worth considering other professions and being a dispute resolution professional for plain vanilla simple disputes to start with, and then, like Pranjal said, make your way up to more complex ones. It's a fantastic opportunity that's available.
I quite agree. And, I would supplement with two sort of statistics which keep on striking me. I think one is that we graduate almost 1 lakh law students every year in this country, right? And to me, where do they find employment? Where is it that they actually go and practice? I think ODR institutions offers at least quite a lot to many of them in becoming dispute resolution professionals. But I think the other more striking fact is that the Indian judiciary, top to bottom, Supreme Court right up to the sub-courts, have a sanctioned strength of probably 25,000 judges. And right now, we have about 17,000 judges in office, right? That gap itself reflects up in the pendency and the burden that the judiciary carries. But to me, equally, the statistics that Vikas was narrating, the kind of volume of cases that is already there and the pent-up sort of thing which the ODR institutions can address, the requirement of dispute resolution professionals, in my view, will be in lakhs to be able to cope with those volumes. And really, that I think is the real sort of opportunity ahead. What I can see, and which I'm very conscious of, we have lots of questions flying in, and I think that speaks to the success of at least the first 40 minutes that we have spent. So maybe if I can just pick up some of those questions and pose them, as we go along. So the first question, which I'm picking from the open questions here, is how do we make ODR platforms accessible to people with visual impairment, color blindness, and so on? Anybody who wants to, sort of raise your hand on this? Yeah, Vikas, please go for it.
I'm not going to say that we have experience of assisting people, but I'm just going to say that we are working towards making it as inclusive as possible. And that's why when we talk about multimodal communications, that's when it comes in. For instance, one of the things that we use is the telephone, the good old telephone. An audio call can actually make a significant difference, not only for visual impairment, but also for illiterate people. So there you're bridging that technology gap in a significantly more forward-looking manner than most other institutions offer. Is that a full solution? No, because you still You're still talking about your notice of arbitration going out in written text, etc. But we are making some efforts to try and address that issue, and hopefully we'll get to a point in time, where we'll have an app which will speak out and read out aloud what is there in the contents of things, etc. We're not there yet, but I think those are some of the options that can be used. But talking about accessibility, which is I think another theme in one of the other questions, is language is another accessibility barrier which exists. Not in high value disputes. In high value disputes, everyone speaks English. But when you're talking about taking it regional, taking it to different parts of the world, people don't understand what it is that we're trying to do. So what we are consciously trying to do is have case managers who can speak the local language. We're trying to have even your written text that is sent to them in the vernacular language in addition to what is there in English. So that way, institutions are not acting as on behalf of entrepreneurs. We are genuinely trying to bridge this knowledge gap, bridge the literacy gap to ensure that justice is truly affordable and accessible.
Thanks, Vikas. I can see another question, which is in terms of while forming rules, what conventions or sets of laws have you, sort of referenced? So maybe Pranjal, if you want to answer that.
Right. So we have two sets of rules which have come out. So like we try to revamp our rules according to the latest judgments. We're a 2019-20 set of rules, and we have come up with the modified rules of 2021. And one is we definitely fully in consonance with the Arbitration Cancellation Act, all the amendments till 2020. And then it also looks at international standards which have been given for ODR platforms. I think the ICOD international standards on online dispute resolution, which have been given by ICODR, is some of the guiding light, even when we try to make our rules in consonance with that, because it talks about confidentiality, it talks about neutrality, competency of the neutrals, all those things, we make sure it's integrated in our rules procedures.
Thanks, Pranjal. Kanchan, would you want to supplement or add anything to that?
No, I think I echo what Pranjal said. I just wanted to add one thing to your previous question, Pramod, if I may, about making it accessible for differently abled people. And, I think Vikas kind of said it very succinctly when he said that, while there are a lot of, it is, as of date, we may not have like the most comprehensive solution, but there are definitely big leaps being made in that direction, for something as simple as, we work in 10 languages as of today. Our platform works in 10 Indian languages. We have IVR based notices. So, somebody gets a phone call and they have the ability to just hear and respond, to a well-crafted IVR saying that, what they can do in a language of their choice. And I think, that is where we believe we'll be breaking barriers to saying that, you don't need to know English or only Hindi to come and be able to resolve a dispute. Dispute can be resolved at your house, in your language, on your at your convenience. And I think that is the most important.
And I think yeah, thanks, Kanchan. Sorry, I was just about to add, I think for the three institutions that are here, but also those that are outside, I think that technology is a great leveler. You should take it indeed into the disabled category as well, for people being inclusively enabled to participate. And to me, ODR is exactly that. For instance, I heard somebody talk about asynchronous or being able to look at documents only. To me, the challenge would be that, can you, for instance, do it as voice calls? Do you necessarily need to do video? And voice, in a way, transcends quite a lot of language barrier, which written communications might sort of have. Similarly, being able to, sort of offer choices which people might not have even heard of or understood, and probably coming out with those. So I think those become really the mechanisms. Right. But very quickly moving to, a few more questions. There's one question which goes to the heart of, what I guess are issues for enterprises maybe. So here's the question: how do we, what are the issues of cost effectiveness, flexibility, and convenience that the ODR institutions bring, and how do you sort of balance it out with, the rules of fairness and neutrality? So maybe Vikas, you want to go at it first?
That is a loaded question, and I think it's a very, very important one. I'll talk about two kinds of disputes and we will answer them. Let's talk about high value complex disputes. the amount of efficiencies that we can bring in is enormous. Percentage-wise, absolute numbers-wise is enormous. So for instance, you're talking about high-value complex disputes. Let's take transcription as an example, right? If you take a high-value complex dispute, which is currently to be transcribed in India, there are no transcription providers in India. So you fly someone from a Dubai or a London or a Singapore, you make them stay in 5-star hotels. That person comes, charges whatever $200 an hour to do whatever they're doing. It is ridiculously expensive. That is being bridged by technology, by making it significantly more accessible to the more complex areas dispute by service providers who provide that service to people, including the same category of disputes, appointment of arbitrators, etc. And there again, we're doing it at more accessible, affordable prices, simply because people need that service. And there, questions of neutrality simply don't arise, because you are doing it at a kind of level as a third-party service provider, so issues of those don't arise. Those issues certainly arise when you're talking about low value disputes, when you're talking about high volume disputes. There, for instance, invariably the person who's giving you the cases is likely to be an enterprise, because your contracts have not yet percolated. I mean, your contractual clauses for COD or CADRE or SAMA have not percolated down to a level where disputes are being churned out of an institutional rules. So you are referring cases which an enterprise is referring to you. There, it's extremely important to toe the line very carefully to maintain that independence and neutrality. And I think there's a number of ways of doing it. One is to ensure that your financial incentives are not aligned with the outcome of the dispute. That, I think, is a crucial barrier which has to be clearly spelled out to parties to ensure that they have that sense of feeling. Second one is all of the things we're talking about in accessibility. It's a perception issue. If you communicate to people, and I think one of the examples that Kanchan gave, where the respondent won, it's a huge kind of a milestone in that institution's journey, where if a person feels that I'm not acting against the service provider and the enterprise, but I'm actually using the service provider to achieve justice, that is a huge milestone to achieve. And that can only be done through a number of ways of making a party feel that we are enabling it. And that, I don't want to go into specific examples of how one or the other institution does it, but I think overall, that's how you need to achieve it.
Thanks, Vikas. I can see still very many number of interesting questions. So for instance, here's one. Would you say the use of ODR system has created a preference for India being chosen as a preferred seat of arbitration? I know we have YMCIA, which is our sort of flag bearer on this. But for ODR institutions, do you think you've made a headway there?
I don't think it's a factor of an institution. It's a factor of the judicial system. It's a factor of laws. Indian judiciary has made huge strides in the last 10-15 years to make it more attractive as a destination. But I don't think we are there yet. We still are in a situation where for foreign arbitrations, for international arbitrations, parties don't want to choose India because they don't see it as a sufficiently neutral enough forum. They still feel that there is a lot of judicial intervention, etc. That is being addressed to a great extent by the judiciary trying to limit it. But parties still prefer foreign seats if there is an international element to it. But again, and I just want to say, we might be missing a whole host of domestic disputes that India is an inevitable arbitration seat for when we're answering those questions, because frankly, the number of Indian arbitrations that are there is in the millions. So to focus on this 10 or 20 or 30 cases of international arbitration that will come and seat themselves here, I don't know if we're missing the wood for the trees there.
Fair enough, Vikas. But just, for the benefit of the audience, I wanted to just add that I think there is a great, sort of opportunity even there in terms of especially the cross-border services or businesses that are carried on from India to have ODR as the means of dispute resolution. Again, when you think about it, there might be multi-parties located in different jurisdictions. For me, for instance, as a bank, we end up providing services to NRIs. Would we want dispute resolution to be centered in India because this is where our seat is, this is where actually the product or service is getting delivered? I would say yes. And in that sense, having ODR, which is anchored in India, would probably make a lot of sense. There's another loaded question, and please don't be shy at all. The question is, what's the highest value of dispute which has been handled over a ODR institution platform? So whichever of you feels comfortable sharing the highest possible number, please feel free.
Right. I think two examples here. One is when Sama as a platform to a local adalat where we saw an insurance claim worth 82 lakhs being dealt with, and one is being seeing a housing finance case of 1.8 crore being coming on the platform. I think these are the two high stake matters, but they are not the norm. They are the exception. The general cases, the general value of claim has been under 50 lakhs.
Yeah. So Pramod, so far as COD is concerned, that's where this question for me is a little unclear, because are you asking me as an institution or are you asking me as a service provider? Because we do both. As a service provider, the value of disputes that has been handled, the highest value of the dispute that has been handled is in the hundreds of crores for us, because we've done mediations and arbitrations of very high value, including one of an arbitral tribunal president sitting in Hong Kong, parties in Bangladesh and India. And so that's just as a service provider. As an institution, what Pranjal is saying is correct. It depends on your sector. So if you're looking at, say, for instance, housing properties, or mortgage against loan against mortgage kind of situations, you're looking at a few crores. So we've had, as an institution, being used for sort of 2, 3, 5 crores to resolve those disputes quite regularly. But when it comes to, let's say, your e-commerce people, or when you come to lease disputes, the value tends to be much smaller. But the cost efficiencies are still there, irrespective of whether we're talking about a few lakhs or whether we're talking about a few crores or a few hundred crores. The cost efficiency is always there.
And very quickly to supplement, Vikas, you had mentioned about automated ODR, and to me, really, those are even resolving disputes of a few hundred rupees to a few thousand. So, I think the potential, as you said, is immense, and we shouldn't get constrained by thinking in value terms. Yeah. I posed it because it was posed by one of our audience. I just now want to ask MCIA, there are still a few questions out there. Yeah, Kanchan, please.
If I may just quickly take a few seconds to add to that. I think an interesting question, in the framework of ODR or ADR generally would also be that what is the lowest value dispute you have handled? I think highest, we all know they, go to arbitral institutions. And at CADRE, considering that we specialize in the low value, high volume kind of dispute category, we've handled cases in the range of 500 rupees. Right, 500 rupees, 1,000 rupees, 700 rupees. We've been able to handle disputes at that level, and I think that is where the power of ODR comes. That even for such small, you don't find it an overkill to do dispute resolution. And before ODR, it would be an overkill, right? That for 500 rupees, where am I going to go breaking my head with the courts, lawyers, or hearings and all of that? So with online platforms, with fast processes, with easy processes, you're able to solve all of this in days at a fraction of a cost. And I think that's what I'd like to add. Yeah.
Thanks, Kanchan. I think I'll pick a couple more questions from what is posted in the Q&A. One was, with government being a major litigant, the curiosity is around whether government bodies from central, state, local, whether on property tax, electricity matters, have been able to engage on this platform, and what's the experience of SAMA, CADRE, and COD on that? So Pranjal, do you want to go at it first?
Right. So again, a few aspects here. Like one is, like, you see state legal service authorities trying to use, again, as a platform, SAMA, to host online lok adalats. And that happened, like we saw it with 5 states, which is Delhi, Rajasthan, Gujarat, Kerala, and Bihar. And hopefully now, as we are shifting back to the pandemic, I think most states will start picking it up again. So that was one. Then we see, like, there's a technology arm to the West Bengal government, which is trying to use for their electricity disputes. Even the notification which Vikas is talking about, the notification which came in 2017, Ministry of Law and Justice, it was actually a push to the government departments. Like, that notification was specifically sent to government departments, telling them that, here, look at this, there are 10 institutions. If you have disputes, make use of them to settle the disputes. It gave us legitimacy, but that notification as such was not used. Like, we did not get any uptake of cases from the government departments post that. But again, another example is the MSME payments portal, which is the Samadhan portal, where any payment disputes with respect to MSMEs, it's not fully ODR, but payment disputes can be handled through that MSME portal. So there are some examples of governments trying to adopt online dispute resolution.
Thanks, Pranjal. We are probably going to be little over time, but I will probably just ask one more question, which is really around the theme of that we talked probably maybe two, we focused on how the neutrals, the dispute resolution professionals themselves is an opportunity. So the question is that is the need of our focusing on that versus focusing on the benefits that ODR institutions can give. So very quick reaction that I wanted to offer is that I think it's a bit of both. I think there needs to be that the institutions have to get fostered, get supported by enterprises, by consumers who can avail of their services. But equally, those who provide that service, it's not the institutions themselves, but it is those dispute resolution professionals. And I think we need to excite them, interest them, and get them into this as much as the people who will choose to get their disputes resolved. So I think it takes both. I don't know if that answers the question which was sort of posed there. Very quickly, there is a question around if unless digital payments are automated and integrated, none of the ODR references would qualify as an IST. How will ODR rules mold to Arbitration Act and relevant judgments? Because I'll need to refer to you. I'm not even sure what IST means, but if you can just tackle that.
To be perfectly honest, I don't quite fully understand that either. But when you're talking about, trying to take payment gateway systems and integrating them into ODR, there are two ways in which that might play out, right? First one is to pay the fees of the ODR institution itself, pay the fees of dispute resolution. That's one way of looking at it. The other way of looking at it is the end-to-end resolution where enforcement also happens on the platform. So for instance, there is an award that is rendered or a settlement entered into, and you allow a digital payment gateway there so that that payment can be made, received at the same point in time, etc. Both of those are laudable goals and objectives. The first, probably most institutions have already tried to achieve that by allowing payments to be made onto their own systems. The second, there are some which have done it, but it's still a work in progress for a few others. But I certainly think that has been necessary in the eventual goal of trying to make ODR a self-sustained institution. So enforcement is one bit that, in the 1 hour that we've talked about, we've not really touched upon because that still has to go back to courts. But if there is some way we can pull it into the ecosystem, if there's some way that we can make that also happen here, it'll be a phenomenal boost to ODR, but that's not yet happened to the scales that we wanted to.
Thanks, Vikas. So again, being conscious of time, I'll just move around the room, maybe starting with you, Kanchan, as to what is the one change that you want to see, for fostering ODR, for it going deeper?
Right. I think all disputes where the government is a party, they should all go on ODR. That is one big change I would like. And I think in terms of awareness, in terms of reach out, nothing can define, the arriving of ODR more than that. And the second thing I want to add is that while it's a slight corollary to the question, Pramod, is that we have seen in my various conversations with people, I've done over 100, more than perhaps 100, I don't know, I've lost count now, sales calls. So we've seen collections teams, we've seen operations teams, finance teams embrace ODR with open arms. The one skeptical person in the room is always from the legal team. So it is we are thankful to the 14 or odd organizations who've taken the plunge and joined us with ODR, but there are 28 others who are still skeptical. And I believe that law is the one that changes, that law is the one that brings about change, and change brings about law. So it is a humble request to all lawyers to, to embrace this with open arms. So those are the
Thanks, Kanchan. Well said, well said. Pranjal?
Right. So I'll keep it short. Two things. I think one is that, as Vikas said, if we can do something about enforcement, I believe our responsibility is like a dispute is not solved just because an award came or a conciliation award was issued. There is post-settlement requirements which need to take place so that parties can actually get the benefit. So if there's some kind of enforcement solution we can figure out with respect to ODR, that will be helpful. Second is, I think there's a challenge we face with respect to e-signing. Enterprises can e-sign, the arbitrators, conciliators can e-sign. but the consumer generally, and depending on the demographics of the enterprise you're serving, they're not always from the tech-savvy demographics, and they're not very comfortable with e-signing. They will follow the settlement terms, but they will not e-sign. So that then becomes like a challenge, and I think we're still trying to figure out how to seamlessly integrate e-signing into these various use cases from the general public perspective.
Thanks, Pranjal. Vikas?
I mean, I've said quite a lot of what I wanted to already. Just to going ahead, I think it's about being open. I think that's the one message that I would want us to take forward, which is be open to use technology. Don't be averse to the idea. We use technology in every single realm of our lives. Our smartphone is now an integral portion of what we do. It really is beyond me why people are hesitant to do it in the dispute resolution realm, where the stakes are so high, where accessibility is that much more important. So I think it's just about being open and being willing to accept some change in your lives.
Well said, Vikas. I think whether it is the march of the law, which is about change, whether it is about technology that has become a great enabler across spaces. The couple of things that I wanted to sort of just highlight for everybody. I talked about how the policymakers have sort of ODR has captured their imagination. I think the judiciary is supportive, endorsing. In fact, Pranjal mentioned it, but just for the benefit of the audience, this afternoon we'll be having a session where Niti Aayog, along with Agami and ONI, are releasing a handbook on ODR, giving several illustrations and examples of how enterprises, how civil society organizations have embraced ODR. And I would really commend it to all of you. And I think there are enough and more, practitioners. There are institutions as the three of which are on this panel. So to me, each of that should be capitalized on. There is nothing to lose, but really all of what we confront as a society, what our judiciary confronts. I've heard it being said that if no new cases are logged into the judiciary, it will take 300 years for disposal of every case that is already there. And to me, ODR institutions can supplement that, whether it is taking out matters that are already pending or diverting those that are fresh matters which might go into the judiciary. And yes, challenges of neutrality, challenges of making sure that there are qualified neutrals on these platforms. And indeed, that the judgments get enforced, the awards and the orders get enforced as they do in the judiciary would be the critical aspects. But with that, it's been a great 1 hour plus session. We've had lots of questions pouring in. I know a few are unanswered, but maybe you can continue the conversations with the three institutions. I'll request each of them to just put up their website or contact links. And in the meantime, hand over to Gaurav. Gaurav, thank you so much for the patience.
Not at all. Well, in the same vein, I would like to thank all the learned panelists for their thought-provoking discussions and great insights, and Mr. Rao particularly for bringing out such a stimulating and engaging discussion on the issue of bridging distance for dispute resolution. I'm confident that, after hearing this session, all the stakeholders will definitely appreciate that the online dispute resolution platforms are a necessary paradigm shift and the need of the hour. I also thank all the attendees for the overwhelming response and interesting questions that have been posed to all our panelists, who have really endeavored to address as many as they could within the time frame that we had today, and making this session really productive and a success. I would like to inform all the attendees that this session has been recorded, as also will be transcribed, and all your friends, colleagues, and acquaintances can very well view this session on the MCI website and on YouTube. And on this note, I would also like to inform that we will now be continuing with the next session at 12 o'clock, which will be on war stories and lessons from virtual hearing in 2020. And on that note, I would like to thank everyone. I hope everyone stays safe and everyone takes care.